program could get an opportunity if they miss us today.
Recording in progress.
Okay, I got you.
Perfect.
All right.
So we are ready.
All
so
right.
Good morning, Trinidad and Tobago. This is Miss Shakila Daniel coming to you live from DL Daniel and Associates for our usual legal corner this morning. Let's talk legal. Your legal information and education program brought to you right here on Street 919 FM every Monday morning at 11:15 a.m. and on Thursday mornings at 10:05. All right. And this morning I am joined by my beautiful colleague. She looks so fantastic and camera ready. Good this morning. Good morning, Miss Peters.
Hi, good morning, Miss Daniel. How are you? Good morning, Robert. I hope everybody's well. You have me blushing this morning. Your listeners can't see me, but I'm blushing. Thank you so much for the compliment.
Yes. You look wonderful. And many of our listeners can see you, actually.
Yes, they can actually see you on YouTube and Facebook. Yes?
Oh, okay. All right. So good morning, everyone.
Okay, great. So we know our listeners, they know that every Monday we usually talk about, because Thursday we leave for family and employment law, and Thursday is property law. And I know that property, the valuation return deadline is in 2 days, no 1 day. Kisha, today's the 29th, right?
Yes.
So I know it's on everyone's mind. And we're going to be diving right into property law today. It's part 2 of the basics in property law. Last time we had Keisha with us, we would have started on, the introduction to property law, kind of explaining what is real property, etc. Today we're hoping to discuss freehold and leasehold, really, freehold versus leasehold. But a little before we get into that, Keisha, what are your thoughts on this, the deadline? Would you encourage our listeners to make sure that they can get all that they can to be ready for tomorrow?
Well, my personal thoughts, yes. You should do all that you can to meet the deadline for tomorrow. It is a directive that was given out, and so all I would say on that, Ms. Daniel, is let's try to be on the safe side of things. Yes. It is better to be prevention is better than cure, as we like to say. So I would encourage persons to do everything that you can to meet your deadline tomorrow, pretty Lord, because you don't want to find yourself in a position where you're facing the consequence of inaction. So.
Yes, very, very true. And we know that there has been a mandate that, there's a fine of $5,000.
$5,000, correct.
Yes, so please do all that you can to have your house in order, literally. And get those things. Remember, you guys can call our office for further assistance on this matter and other issues. Feel free to call the office number 241-3772, 241-3772, or cell after the program, 769-6410. 769-6410. I know a lot of our listeners wanted to get a copy of their deed. They needed to get searches done, certified copies, etc. We will try our best to facilitate these things. Remember, DL Daniel Associates is a legal administrative firm. It is privately held and owned. It is not a government service. All right? I want to remind our listeners of that. All right, Keisha, Miss Peter. So let's get right into our topic this morning. We're talking about leasehold, freehold versus leasehold. Sometimes let's talk about that. When we speak about freehold and we speak about leasehold, what does that mean? Let's start off most basic and simple.
All right. So before I deal with that, I want to recap. The last time I was here, we were dealing with the definition of real property, and for persons to understand that when we talk about land, we're not just talking about the ground, but everything that is attached to it, and that's how we've started differentiating the difference between a fixture and a chattel. And then, to come right to your question this morning is that, oftentimes persons who are interested in purchasing property whether they are opening up the newspaper and looking at the classifieds, or in more recent times, they're joining all of these million groups on Facebook or Instagram that are selling, persons purporting to sell land. You'd see freehold land for sale or leasehold land for sale. And, people come to you and they don't understand what the difference is. So that leads us directly to your question. Freehold land. When we talk about land being freehold, it allows a person to actually use and enjoy the land for the duration of their entire life. And if they please, that of their heirs, which means that they can gift the property during their lifetime, they can leave the property in a will for their great-great-grandchildren, if they may. It is equivalent to permanent ownership of the land, unless, of course, you decide to sell that land to someone else. So that when we talk about land being freehold, it equates to permanent ownership. You can treat with it and you can do with it as you please without anyone else's permission. On the other hand, leasehold property does not give the same rights and freedoms to the individual or the people that hold the leasehold interest. All right? The person with the leasehold interest is only given the right to possess, use, and enjoy that land for the fixed period of time, that often being the term of the lease. So when the lease expires, the ownership or let's just say ownership, but the ownership never really changes. When the lease expires, the right to possess and use and enjoy the land also expires.
Right, wonderful. I think that was really, really clearly put and explained and as simple as possible. So just to reiterate, and I try to help clients sometimes understand this easily. I say freehold, you hold it freely. you hold your land freely. And lease, because another word for lease could be like loaned or lend, right? It's loaned to you. And most importantly, you mentioned there a phrase that sometimes people get confused on. You said with lease, one of the things that differentiates freehold from lease, so when you're looking at a title document, is term. Could you define term for me in law so that our listeners could get some clarity?
Well, if I can explain it in its simplest form, I don't want to use the word term in simplest terms, that is the period of time that you are allowed to use, possess, and enjoy the land. So different persons hold different terms based on their leases. So there are long leases. Sometimes you want to buy a property and they say, well, we have a lease for 199 years. Now, this is something that you need to be careful with. And pay attention to the fact that the person who holds the freehold interest can actually give another a leasehold interest in the property. So let's say that you're buying land or you're looking at house and land and they're giving you a lease for 199 years. The ownership of that property does not convert or does not transfer to you. You just have the right to use, possess, and enjoy that property for 199 years. So let's say that 180 years ago, Shakila, your great-great-grandmother got this leasehold property for 199 years. And now in 2021, it really just has 19 more years to go. All right? At the end of the 19th year, what happens?
You have to renew your lease.
Correct. You would have to renew the lease or seek to renew the lease from the individual who presently holds that freehold interest. And similarly, when persons are transferring lease, and this is something that persons use or they say all the time. They come to you and they say, well, Ms. Peters, I want to buy the property. You cannot buy the lease. What you can do is assign the lease to someone else. And even in assigning the lease, you oftentimes need the consent or the permission of the freehold owner, correct? And then we see it all the time. Let's say someone had a lease for 30 years and they want to transfer it or assign it to someone else. But 25 years has already passed. What you are getting, ladies and gentlemen, is not a lease for 30 years. What you are getting is the remaining number of years, which would just be that 5-year period. So it's very, very important when you're entering into real property transactions that you understand the interest of that is being conveyed to you. So when we say that, when we talk about the interest that is being conveyed, we are talking about whether or not it's the freehold interest in the property or the leasehold interest in the property, because both interests carry different things as to what you, the individual, will actually be receiving.
Yes, very, very important information. And we have a lot of properties that are governed under leasehold interest or title. A lot of developments often opt, whether it be government developments or private, when you see the person's deed, right, they read through it, you would recognize that it really is a leasehold interest. They may have gotten 199 years, sometimes 999 years. You have leases for that long. However, it does not transfer ownership to you. It's a right, a possessory right, so to speak, in being able to possess the land. And the assignment, Keisha, you mentioned something there in terms of when, so a transaction may be happening and someone has a 199-year lease and they want to assign a 30-year lease to a buyer, right? Oftentimes persons do not read to see, well, how much of that 199 years is remaining.
Correct.
Because you may see the 199 years and assume that, but you don't know if that person would have inherited that from their great-great-grandfather and they only have 19 years left, 15 years left, and trying to sell you a 30-year term. So it is really important to have your title documents read, interpreted, and explained, right, by an attorney at law and or someone qualified that is equivalent to understand conveyancing and understand property law. In terms of selling of leasehold versus freehold, because I often see on these same Facebook groups, Keisha, oh my gosh, I am so very concerned about these Facebook groups, right? Because I call them Facebook lawyers. And people give a lot of advice there in terms of the pricing. Now, we know the cost for land is determined, the different market value, and there are different things that affects the cost of land, right? Mm-hmm. In terms of the price point for leasehold land, do you think that buyers should be aware if the cost, should there be a material change in price offering between leasehold versus freehold, in your opinion?
I often encourage persons to have a valuation done on the property in order to, when you do the valuation, Shakila, you see whether or not the vendor is asking for exorbitant fees or the vendor realizes whether or not they are under asking in relation to the property. And so oftentimes people will call a figure out of their head. I feel I want this, and this is what they're going to put there. And a lot of the times there are, I don't want to use the word horrendous, but the markup on these properties is so much, all right, that I often always tell the people, let the buyer beware. You have to be, especially if you don't have knowledge about real property, seek that advice, seek that guidance. Go to an attorney at law, get someone who's qualified to go with you to assess the place, to indicate to you whether or not the calling price is exorbitant as opposed to what the market price would be. You have to inform yourselves, especially when you're going through these transactions. And please do not take, as you said, the Facebook lawyers, the advice of the Facebook lawyers, because we see persons, sometimes they don't even put freehold or leasehold property. Shakila, when you go on to it, they say deed in hand. And as you read further, you realize what they really have is a certificate of title. And my heart starts skipping beats because I am like, no, you cannot transfer land through a certificate of title.
Let's talk about that because a little bit. I know that we will have to go into that deeper in a part 3 for property, really. But it is
not a certificate of title. I have to correct myself. Not a certificate of title. What LSA gives you, the certificate of comfort. So let me correct that immediately. You can transfer title through a certificate of title. A certificate of comfort is something completely different. All right? You cannot transfer land through a certificate of comfort. But I know that Shakila understood what I meant.
Yes, I did. So because certificate of comfort, persons often call a deed of comfort.
A deed of comfort, yeah.
Time and time again that you cannot buy land with a deed of, you cannot sell land with a deed of comfort, and you should not buy land with a deed of comfort. So I'm hoping by now people understand that and why.
Well, Shakila, they call it a deed of comfort, but just for the avoidance of doubt, nothing like that exists. There is nothing called a deed of comfort in law. All right? Your good hard-earned money will be taken and you will be left with the consequences, unfortunately.
Yes. Right. And you know, that term, that Latin term in law, caveat emptor, is so very important because, you know, sometimes when people already lose their money, they do not get legal advice before. They do not do any due diligence. They do not do any searches. And when they have already, you know, lost their money, they want to come now to fight to get redress when it's already done. But the responsibility really in law is on you, the buyer, to make sure that you check and make sure that everything is right when the vendor or the person selling is offering you it. You have a responsibility, and sometimes people shy away from spending money to do their due diligence, but they lose so much in the end. Buying property is not a shock transaction, right?
Right.
Especially if you're not going through the banks. And you don't pay for them to do their due diligence because they are very meticulous when their money is involved. You should also take suits and do the same. Now, Keisha, we mentioned certificate of title there. And, you know, that is something persons get very confused about in old law versus RPO or the lands under the RPO or the RPA now, right? That deeds is under the old law, and that certificates of title is under RPO, and how the transactions have to happen is different.
Correct.
Right? So the RPO lands, could you, because I recognize a lot of persons have a difficulty with understanding when they have RPO land, what is the material difference, etc., and what are some things they should look out for and ask the buyer to present when being offered.
All right.
Ask the vendor, to present.
All right, so the first thing that our viewers or listeners need to understand, Shakila, this morning is that in Trinidad and Tobago, there are two systems of land titles. So the first we call the old common law system, which is guided by the Conveyancing and Law of Property Act of Trinidad and Tobago. And secondly, which you were asking about with the certificate of title, that is under the registration of title system, which is governed by the Real Property Act. So if it is that you have a deed if you have a deed, then you are under the old common law system, or your land, the land title is under the old common law system. But if you have a certificate of title, then you are under the registration of title system. What persons need to understand is that one is not better than the other, or one trumps the other. All right? No, it's just two different systems of titles that we have. So you can have a certificate of title, and your neighbor across the road or next door to you can actually have a deed for the property. All right. So the registration of title system, or where we get the certificate of title, actually came about to try to simplify the old common law system. Now, again, persons need to understand that there is no deed under the system. All right? What no deed is, there is no deed. There is a certificate of title.
So now, what we call a CT, right?
The CT for short. Correct.
Right.
The CT for short. So,
and how a CT is registered? How would somebody know that I have a CT and not a deed?
All right. So there are, for each parcel of land under the system, there are 2 certificates of titles. One that is permanently kept at the land registry for safekeeping. So that nice big building that they built down the road on Ryson, the corner, that's what, Richmond Street and Ryson. Yeah, and Ryson Road, you go down to Legal Affairs and you get a search done. You can hire a competent, you hear the word I'm using, a competent search clerk to search the parcel of land to see whether or not there is indeed a certificate of title lodged at the land registry. Once that certificate of title is found, the difference, one of the major difference between the certificate of title and the deed is that the back of the certificate of title has every single transaction that has happened in relation to that land. As opposed to a deed, you have to go now and search for a different document each time. So you're telling your story or you're doing your search in relation to the deed, you have to go and look for the next deed. Whereas with a certificate of title, each transaction is endorsed to the back of the original. Well, it has to be endorsed on the back of the original copy held by the registered owner as well. So when you get the copy of the certificate of title, it tells you everything. It's right there for you. All right?
Yes. So I don't need to cut you. But we run out of time. Yeah, we run out of time. We want to take some time to get our callers, our listeners, to call in and ask any questions, queries, or concerns they may have. I want to also remind them that such competent title clerks do exist right here at the Daniel Associates, right? So you can call us as well for that service. That's actually what our firm is really known for. We pride ourselves on being quite comfortable with conveyancing and property law. And we do comprehensive, really, I can vouch for our searches, yeah? So if you would like to have a title search done to understand what is the story of your property, the lands that you're on, your grandmother lands, your grandfather lands, etc., feel free to call us to have some assistance with that. The numbers to call 241-3772, 241-3772 or 769-6410 after the program. Because Keisha, I tell persons with property law, everything starts with a search. All right. Everything starts. The story begins. It's like the once upon a time of transactions. You have to start with title searches.
And oftentimes persons have no idea what it is that they are selling.
Correct. I have seen instances where the title search helps the vendor and all observe that they have some encumbrance on their own title that they may not have known of, and they inherited from the person that sold them before. So they bought it without knowing the encumbrance, and our new client now unearthed an encumbrance that they didn't even know about. So title searches are very, 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 very important, especially I would go to liberty to say, because I've been doing this for many years, that we have a very interesting culture of property law in Trinidad and Tobago. That's as far as I will say. It's a very interesting culture of property and conveyancing. So please be very, very careful. So, yes, he told me his name is not Kyle. I think it's Robert. Robert, can you open the lines for us real quick so we can have our last
all right, so you guys know the numbers to call. Of course, 342-0081. 771-1791 and of course 46653.
We want to open up our lines now to invite our callers to call and to call and ask any questions.
Yes,
I remember
for
callers.
sure. Yes.
Thank you.
So those numbers to call, or we have a caller already on the line.
Right.
Hello, good morning.
Hi, good morning.
Good morning.
Is this the live radio talk show?
Yes, it is. Morning. Welcome to Let's Talk Legal.
Hi, good morning.
Good morning.
Morning.
Go ahead,
Welcome
caller.
to the program.
I'm
Go right
to
ahead.
find out something. If I have a property, right, and I have a, what you call a probate, are you hearing me?
We can't hear the caller.
Are you hearing me?
Yeah, we're muted. Caller, we can't hear the question.
Hello, are you hearing me?
Yes, caller, go ahead.
Okay. I have a property, right? Was I got that property, and I did the probate for that property. I haven't received a deed as yet, but I want to know if I can give to a daughter of mine a piece of that property as a gift, and how long would it take?
Wonderful question, caller. Thanks for that question. All right. So that is a question that has two of my favorite things in it. It's a probate question and a property question. Getting some feedback there. Would you encourage the caller to call us after the program at 241-3772, 241-3772, or 769-6410, 769-6410, because that requires particular and specific advice. And we cannot give advice on air, cannot give legal advice on air, but it's a beautiful question. I can't say that it includes, Keisha, are you still with me?
Yes, I'm here.
Yes.
I'm struggling a bit to hear with all the feedback.
Yes, she would have asked. She said she has she's going through probate for the property. I believe she has not been given her grant as yet, and or deed of assent, and she's interested in, after doing gifting the property that she would have been granted on the probate after. So if it's possible, I could go as far as to say it's possible.
All right, guys, we have one more caller on the line. Caller, good morning.
Good morning.
Good morning.
I have been listening to the program, and I didn't hear mention made about the Sagaramas lands, which 99 years were given to the owners of lands down there, and what is possible now when that 99-year lease is up. Can you inform me a little better? I will repeat again. The Sagaramas lands, which the United States had the base. The people who own lands there got 99-year leases. There is about something like within 20 more years left. But what happens when that lease is up? What can the present owners do?
Wonderful question, caller. Thank you so much for your contribution. Ms. Peters, you would like to answer that generally?
All right, so generally all leases, it will follow along with what we were discussing before. All right, but I cannot answer the question specifically because, of course, I don't have your lease in front of me. But generally, leases would include a term or provision that allows for the renewal of the lease for a further or think about it like an extension of time. So what you need to do is get your documents, go to an attorney at law, a competent attorney at law, and have them review the document in order to ascertain whether or not at the end of the term of years you can now seek an extension of your leasehold interest. All right, and that operates for all leasehold properties.
Yes. So it really is, you have to look at have your lease read and have your lease reviewed, right? And see what provisions within it is given for renewal. No lease is the same, no lease is created equal, and so it would be important for your lease to be reviewed, as Ms. Peters would have said, by a competent attorney at law.
All right, because at the end of the years, you definitely don't hold the freehold interest. So you need to seek to have that lease renewed for an extended period of time. That would be in your best interest to have that done.
And Keisha, it reminds me of lands because we are located at number 1 Taylor Street and Arpita Avenue in Woodbrook, right? That's where our office is. And our lands here, there's no one in Woodbrook with freehold interest. A lot of these lands from the government of Trinidad and Tobago are leased for sometimes 30 years, etc. And there's with the city, Port of Spain City Corporation, there are requirements for the renewal of these leases in accordance to what they require. That caller would have spoken about its Sagaramas lands being given by the US, etc. They will have different requirements. So it really boils down to the freehold owner and in your lease, what are the provisions and the requirements in accordance to your specific documents, all right?
Correct, Shakila, because I know as well that certain parts of ARIMA, it is the same as well. So that recently, my office was engaged in renewing a leasehold interest through the ARIMA Borough Corporation. And again, it was the terms of that individual's lease that would have governed the renewal process.
Yes. So the renewal process is governed by the lease itself. That's the simplest answer for that question. We have any other call on the line?
No, not at this present time.
Right.
Not at this present time.
All right. So I believe that we are just about out of time. It says that time flies when you're having fun.
Oh, yeah.
Right?
All right. We have one more caller. Let's take this one.
We have one more caller?
Yes.
All right. Caller, good morning.
Good morning, caller.
Good morning. Always very insightful, the information that is being given. The lady says that they are located in Woodbrook, and certainly they are attempting to connect the dots for the proper administration of property and stuff like that. The Woodbrook properties are leasehold properties. And so does your office also pay attention to the way in which valuations are being done in places like Woodbrook? So, for example, there are valuations that are being given, and many persons would have, it's leasehold property, okay, let's be clear on this. Many persons would have added an annex to the perimeter wall. It means that they would have put up 3 sides and used the boundary wall to form a building. And you have valuators who also own property in Woodbrook, and they are vicariously giving values to these properties for illegal structure, thereby sending up the value in Woodbrook and nurturing and stroking their property value that they have and their friends and family have in Woodbrook. So is your organization also monitoring?
Yes. Thanks so much, Paula, for mentioning that, and that's true.
All right, thanks so much, Paula. Listen off here.
Hello?
Hello?
Yes.
Yes, go ahead.
Yeah, so he's alluding to property in Woodbrook and the valuation of this, we are not valuators. We're not here this morning to talk about, how property should be valued. Valuators are governed. They have their own governing body that controls how they operate and what they should and shouldn't do. What we can speak, though, in terms of Woodbrook, most of the properties that I've mentioned is leasehold, and persons with title in this area should be aware, even if they're doing, because I sometimes see persons, they're doing a probate for their great-grandmother or so, and they want to probate the property owned, but it was a leasehold and the lease expired. You have to take care of that before trying to probate it, all right? Because even if you are granted the probate, but the title that you included in the inventory as part of that application is not sorted out properly, and you still will not be able to be assented. Keisha, you're following, am I correct with that?
Yeah, I'm following, correct. Basically, when you're going through a probate, the probate is for what items the estate actually had. All right.
Yes.
If it is that your lease expired, then that means that there is no leasehold interest to be had at the date of death of the individual. So it cannot be included on, what we call the inventory as part of the assets held by the deceased person. So if your lease had expired, and Shakila, persons oftentimes they get upset with you, when you tell them that, but it is the law and it cannot change. If the lease had expired, and the unfortunate thing about it is that we have a culture where we think that everything will resolve and see about itself.
Yes. And I see it happening so much with the Woodbrook properties. That's why I'm trying to reiterate it. Because those leases are short. A lot of times they are 30-year leases, and sometimes people go for granted, or their grandparents got it for the remainder of somebody else's lease. So they didn't even realize that their grandparents didn't have the 199 years, but they really had 50 out of the 99. And this was 60 years ago. And even though you are on the land, you are in the house, it doesn't mean that you have interest or that you hold it still.
Correct.
Yeah.
So it might very well be a situation where our first podcast comes into play. So Granny built the house, but she built the house on leasehold land, and so what the house amounts to would be a chattel.
Yes.
And not a fixture. So, guys, it's important to put your house in order.
Put your house in order. Keisha, thanks so much for joining me for this program. I always have fun talking about property.
Of course, always a pleasure.
Right. So, unfortunately, we're out of time, but we want to encourage our listeners to please tune in with us again. We will be here back on Thursday for our next segment of Let's Talk Legal. Thursdays, our segment is on at 10:05 a.m. Hopefully, we'll be able to speak a bit. We will be continuing on family law. All right. We will have Miss Avian Joseph there joining with us. She will be continuing. We'll be talking still about custody after divorce or custody for children and family law. We have to talk about maintenance, child maintenance for minors. So stay tuned for that topic happening this Tuesday at 10:05 a.m. right here on Street 919 FM, brought to you by D.L. Daniel and Associates Limited, Legal Administrative Consultancy. Remember to call us at 241-3772. That number again, 241-3772. 241-3772 or 769-6410. 769-6410. Keisha, thank you so much for joining us.
Of course, my pleasure.
And looking so pretty. Looking forward again for next time. All right, Trinidad and Tobago, till next time, take care. And remember, your legal right is your legal obligation. Make sure and take your constitutional right to know your laws. All right? Join us next time. And until then, stay safe. Goodbye.